Alexis, we were talking about a landlord-tenant law. We have an attorney here, Caleb Maggio, that generally represents landlords when it's time for them to evict tenants. And
Mm-hmm.
when you file that tenant eviction, well, all lawsuits start with a summons, where it is a copy of the complaint and the summons is served on the defendant.
Mm-hmm.
The typical summons is a 20-day summons. It tells the defendant that they have 20 days in which to file an answer, or a default judgment will be entered against them.
Mm-hmm.
When you file an eviction against a tenant for non-payment of rent, there's actually two summonses. There's a 5-day summons and there's a 20-day summons. The 5-day summons has to do with possession of the property, so that the tenant must file an answer within 5 days as to why they should be allowed to continue to occupy the rented premises. If they don't, the landlord can get in a default judgment and start right away with the eviction process, kicking them out of the house. The 20-day summons has to do with damages, as far as if the landlord is trying to sue the tenant for additional damages for unpaid rent or for damages done to the property. That one gives the tenant 20 days in which to file an answer, or a default judgment would be entered against them. So when we talk about lawsuits lasting for months and months and months here in the state of Florida, to do an eviction really can just be a matter of weeks, and that's good news for landlords.
Yeah, it is.